Do I need a lawyer for a trust? Have you ever wondered if you really need a lawyer to set up a trust? This is a common question many people face when considering estate planning. Let's break down the details so you can make an informed decision. First, it's important to understand what a trust actually is. A trust is a legal arrangement where property or assets are transferred to a trustee. The trustee manages these assets for the benefit of one or more beneficiaries. Trusts can be revocable, meaning you can change them while you are alive, or irrevocable, meaning they cannot be altered once established. Now, let's talk about why you might need a lawyer. Drafting a trust document is not as simple as filling out a form. It requires legal knowledge to ensure it meets state laws and clearly outlines the roles of the settlor, trustee, and beneficiaries. A lawyer can help create a trust that accurately reflects your wishes and avoids any confusion. Funding the trust is another critical step. This involves transferring assets, like bank accounts, into the trust. Banks and credit unions often requiring specific documentation to retitle these accounts. A lawyer can guide you through this process to make sure everything is done correctly. They can also help revoke any prior designations, such as pay-on-death beneficiaries, to prevent conflicts later on. Understanding trust distribution rules is essential as well. These rules dictate how and when assets are distributed to beneficiaries. Legal advice can clarify these rules, ensuring they are enforceable and preventing any disputes down the line. For those considering credit unions, there are additional compliance issues. Trusts must meet membership eligibility requirements. For instance, either the settlor or the beneficiaries need to be members of the credit union before creating an irrevocable trust account. A lawyer can help clarify these requirements and assist with compliance. However, there are situations where you might not need a lawyer. If you are setting up a simple revocable living trust and feel comfortable with the process, some banks and credit unions offer guidance. Additionally, there are templates and online services available for basic trusts, but using these carries risks if they do not fit your specific needs. When working with banks and credit unions, proper documentation is key. Errors in paperwork can lead to delays or issues with account access. Trust accounts with multiple beneficiaries may have higher insurance limits, but correct titling and documentation are critical to ensure coverage. Trustees also have fiduciary duties to manage and distribute trust assets according to the trust terms and applicable laws. Understanding these responsibilities is vital for effective trust management. In summary, while you may not always need a lawyer to create or manage a trust, having legal assistance is highly recommended. This ensures the trust is valid, assets are properly transferred, and distribution rules are clear. For complex trusts or significant assets, consulting a lawyer is a wise choice to protect your interests and those of your beneficiaries.